All right. Well, good afternoon, everyone. Hope you're all having a great day and staying warm. Today, I know we're kind of bundled here at the office. I'm Lee Leppert. I'm the Senior Creative Manager here at the Cromeens Law Firm. And today we have Miss Karalynn Cromeens. She is a published author, award-winning lawyer, owner, and seasoned managing partner of the Cromeens Law Firm, and also the owner of the Subcontractor Institute, which is an easy access online educational platform for contractors. Karalynn has practiced construction, real estate, and business law for over 17 years and really has made it her personal mission to educate contractors on a national level. And today she is here to educate the Texas contractor on what is expected of you to collect on your construction projects and really just know the fundamentals of the collections process. Today we'll discuss how to trap funds, how to collect retainage, reveal sham contracts, and of course share all the new updates for Texas liens that you must understand. This went into effect as of January 1st of this year. So lots of really great information and knowledge that Karalynn will share with you today. And just a few housekeeping things. Please remember to remain muted during the presentation and use your fill in the blank handout that was sent to you via email. You'll be able to follow along with the presentation today. I will be sending out, we record this session, so this will be added to our YouTube channel as well, so you can always refer back to it or share with members of your team and colleagues. And we will have that Q&A portion also at the end of the presentation. So please feel at that time to submit any and all questions you have via the chat. You can also unmute yourself and ask Karalynn directly any questions you may have. This really is the perfect time for you to get any and all questions you have with a licensed attorney. So we hope that you take advantage of that time. I know a few of you are probably all going to be trickling in. We had a great sign up rate, so this is a great lesson for today, and we're just eager to kick off the new year with you all. So we hope you join us. We have educational content for you throughout the year, webinars every month, so lots of good stuff. So be on the lookout on our social channels to sign up for all of our new things that we have to offer this year. All right, well, without further ado, I'm going to have Karalynn go ahead and take it away.
Hey, good afternoon, guys. Oh, what a great day. I'm so glad that you're here. So I have a 1 o'clock hard stop time. So I'm going to talk. There's a lot of stuff here. I don't know if I'll get to it all. I'm basically going to talk to until 12:45, and then I'll open it up for questions. If I don't get to something you have a question on, you can always shoot, set up a call. We can talk about it, or shoot me an email, and we can kind of go from there on how to get your questions answered. One of the most, before we, consistent collection strategy, before we dive in, for those of you who are unfamiliar with me, I'm the owner of the Cromeens Law Firm, but what I'm really trying to do is level the playing field and bring respect back to subcontractors and people in the construction industry. And a big portion of, a huge portion of being respected is being paid for your work. And so today I come at this strategy with, yes, this is a collection strategy. I know how hard you work for your money. Because I've started my own material supply business in the past, and so I know how much it needs to be protected, and that's what we're here to do, and help you. And if I don't address something you have a question on, like I said, put it in the chat. I'll answer it at the end, or feel free to reach out to me at any time. Okay, so creating a collection strategy. Why is a collection strategy so important? Well, especially in the construction industry. Okay, so in the world, there's two types of debts. There's unsecured debt and secured debt. So like when you have a credit card, like a Home Depot credit card, if you run up a bunch of charges and you don't pay the bill, they have to sue you, get a judgment, and then find assets to collect. That is an unsecured debt. That's what you have if you don't have a lien. Now, a secured debt is like a mortgage on your house. When you go to buy a house, you can't afford to pay cash, you go get a mortgage, the bank gives you money, and they take back a lien on your house that says basically, if you don't pay me, if you don't pay the bank, they're going to foreclose that lien and take back the house. So their debt is satisfied by that. That's the same thing as what a mechanics and materialman's lien allows you to do. So you can be secured in the money that you're owed for the value of labor and materials that you improved a property with. So it's the value of work or materials that you've provided to the project that you can lien for. And the end result is, and we hardly ever get this way, if you're unpaid, you can enforce that lien by foreclosure. And the long and the short of it was, the end result would be you could sell that property to satisfy your lien claim. Now, 99% of places don't end up that way, and we don't want to end up with a piece of property. We want to get paid for the money that we're owed, right? So but that is why a lien is such great leverage. So next slide, Lee, please. As we're walking into 2022, this is a great time to start off your goals for this year. And look at what last year looked like. So for 2021, if you didn't write off zero, you're going to try to get whatever percentage of your gross revenue that you ended up not collecting, you're going to try to cut that in half, right? So if you had written off 5% of your gross revenue, right? So, and then we're going to try to cut that in half in 2022 to 2.5% of your gross revenue with a consistent collection strategy. You guys, you're in business to feed your families and support the employees that work for you. You can only do that if you have the cash that you're owed for the work that you're doing. So this is all about helping you to think of the components that would take, because a lot of it you can do on the front end before ever hiring a lawyer. All right, next. This is so the good collection strategy starts before you decide to extend anybody credit. So when you go work on a job, or you supply materials and then you wait to get paid, you're extending that person, whoever hired you, credit. And then you're going to wait to get paid. So we want to be in the best position possible to collect that money. So if you're a material supplier, you're going to want to have a good credit app. If you're a subcontractor or a residential contractor, you're going to want to have a good contract. Subcontractors, we can get into a whole nother webinar about that, but at least know if you have a pay when paid clause or things that might affect you getting paid on time in your contract. So it's clear, if you're a residential contractor, being upfront about when payment is expected is hugely important, spelling it out as clearly as possible. And so that's what you can do on the front end, as well as collecting information about the project, like who's the general contract, the project address, so that way if it does end up in collections, that you have all the information And then the liens, there's lien timelines that are different in all 50 states, feed into that collection strategy. So on the front end, you're getting a credit app, you're getting the contract, you're getting the who the general contractor is, the project address, and then we're going to work that into, okay, when's the first time I gotta do something to preserve my lien rights? And today we're talking specifically about Texas and the new lien laws that go with Texas. So all of that, is what we're going to kind of go through today. So the basics for liens in Texas. Okay, so in Texas, there's two different types of liens: constitutional versus statutory. A constitutional lien is when you work directly for the owner, whether that's the owner of a house, owner of a commercial building, an apartment complex, or the management company for an apartment complex. And when you have a constitutional lien, there are a lot less steps you have to take to have a valid lien, because what the law says, if you hired them directly, you know that they're working and you know that you owe them money. So there's a lot less steps. Now, a statutory lien is anybody that is not in direct contract with the owner. So, like a subcontractor or a material supplier, someone who does not have that, direct line of communication hired directly by the owner has a statutory lien. And what we're going to dive in today is mainly the statutory lien, because there are a bunch of notices and steps that have to be perfected to have a lien perfected, and therefore making the amounts you're owed no longer unsecured, but a secured debt, which is where everybody wants to be, because you're more likely to collect your money. That's what matters at the end of the day. All right, so the first steps in any state and in Texas about knowing when you first need to act to have a valid lien is knowing your place and the type of project. And so when I say place, can you go to the next slide? Thank you. This is what I'm talking about, the construction food chain chart, which most of you know. I just kind of put it in, so like the general contractor's place 1, subcontractor place 2, and then below that is place 3. Because they're referred to as different things all over the country. Sometimes the general contractor is referred to as original contractor, or they have different, but if we just give them place numbers, we know what level we're talking about. So like I was saying before, place 1 is a constitutional lien. Okay, so before, constitutional liens really had no rules at all. You could file them whenever you wanted to. Well, for contracts, and so when we get into the new lien rules for that were effective January 1st of this year, they only affect original contracts signed on or after January 1st, 2022. So if you are a subcontractor or material suppliers, these new rules are not going to be in effect yet for you, because you're working on jobs that have contracts that were signed, a year or 2 years ago. So I tell you these new updated rules, but with the proviso, they're not really going to take effect until some point later on. So but if you are signing a contract directly with an owner and it's after January 1st, 2022, the new rules currently apply to you. Okay, so that's the big, I don't know why they did it that way. It's kind of because as a subcontractor and a material supplier, you have no idea when the original contract is signed. But I can say that the updated rules require less. So if you stayed under the old rules longer, you'll be covered because it's actually more. You'll be covered. And so for what I'm telling my clients right now, the subcontractors, material suppliers, let's just stay under the old rules for right now, because I have no idea when the original contract is signed. And we can revisit that the next year. Okay, can we go back one more real quick? Yeah, okay, so what I was saying in the beginning, the statutory and constitutional. Before, there was no rules for constitutional liens, really. When the updated rules take effect, so if you contract with the owner, you now have a timeline to file your lien, which wasn't in effect before. So if you're working on a house that somebody lives in, your timeline is the 15th day of the 3rd month after last work that your lien has to be filed. And if you're a subcontractor or somewhere further down, I'm sorry, if it's a commercial project, then it's the 15th day of the 4th month. So now the people in place one, the original contractors, have a timeline of when their constitutional lien needs to be filed, which that's a big update. So be wary about that in situations where you are contracting directly with the owner. Okay, now next slide. Okay, so the first action you need to take to perfect your liens depends on your place. So like I was saying before, and so the further you go down the chain, the more likely you're going to have to act early. So under the current rules, people in place 3 need to send a notice to the people in place 1 by the 15th day of the 2nd month, right? So if you are working in January, by March 15th, you are sending the general contractor, the place 1 contractor, a notice, basically a statement that says, hey, I'm owed money, I haven't been paid, and you need to pay me. Okay, so that is the requirement for place 3. Under the new rules, that notice is no longer required. But like I said, I'm very leery to say take those actions because we don't know when the original contract was signed. And then the closer you are up the chain, you don't have to act as fast. So like a place 2 contractor, and under the new rules, everybody on a commercial project, it's the 15th day of the 3rd month that you need to send out an intent to lien, and it goes both to the original contractor and the owner. Okay, so, all right. And then the next step you need to know about when to take action is the project type, okay? So for a homestead, homesteads in Texas are protected at all costs, and so it's really hard to have a lien on a homestead. But what a homestead is a residential property owned by the same people that are living in it on a full-time basis. It's not a beach house, it's not a second home, it is where you live, it's where your driver's license is registered. That is a homestead, and we can get into later on, if we have specific questions about homestead liens, email me and we can get more into that. You can't have a lien, it just requires a little more. A residence is a single family home all the way up to a quadruplex that is owned by 1 or more individuals, and one of the owners is living there. So, and there's not as stringent as requirements on residential. Commercial are all projects that don't fit into one of these other timelines. So apartments, multifamily, anything like that. Okay, so then you have Texas Public Works, which is like fire stations, police stations, jails, unless it's a federal jail, libraries, and then federal projects, which are like airports, naval bases, and so those all have different timelines. But those are the different types of projects in Texas. a sham contract, I'm just going to hit this shortly. So the places that we went over, we said place 1 has a constitutional lien, right? If the owner and the general contractor are 2 different companies, but they're owned by the same person, what the law says is that place 2 contractor can now have a constitutional lien. So something to keep in mind if, and you know, it just kind of depends on the situation, but this is not uncommon where an entity owns the land, especially when we're building spec houses, you know, David Weekley, D.R. Horton kind of thing, is one company owns the land, which is the development company, and then another company, which is the construction company, builds it. So they're 2 different companies, but they're owned by the same, you know, the same people. So then the place 2 contractor, which would normally be considered a subcontractor, would then have a constitutional lien and not have to follow all those stringent timelines. Okay, so that's what it is and why it matters. All right, these are the technical requirements for a lien, and I know this is in your handout, so I'm not going to go through it a lot, but that's what has to be in a lien for it to be valid. Missing one can make it invalid. All right. All right, the steps to have a lien. Okay, so one of the most important steps of having a valid lien is notice. And you can understand why, right? If you're going to have a lien on somebody's property that could end up in the foreclosure of the property to satisfy your lien, that is a major remedy. That is a lot of leverage. So in order to have such a great remedy, to such a great right, there's a lot of steps that you have to follow to get there. One of them is notice. And the purpose of notice is to give like the owner a chance to know that you're not paid before they pay the general contractor or before the general contractor pays the sub, so that they don't have to pay twice, right? So that's the whole purpose. And I'm going to go over these very technical timelines, but know that there's no penalty for sending notice early. There's only a penalty for sending notice late, right? You can send it early, often as much as you want. You just can't send it late, and not enough is what's required. So if you know there's a problem, there's no use in waiting. And you know, go ahead and send a notice or contact us and we'll help you figure out who to send notices to. All right, so another thing, especially in Texas, it's different in all 50 states, but in Texas, when you are looking at the timeline for notices, it starts from the first date that you're owed money, right? And each month has to meet its notice requirements on its own. So if you were working, like you're working January, February, March, right? You get paid for January, but you're still owed from February. Your notice timeline goes from those February timelines. So it's not the last time you did work. The timeline for filing a lien goes for the last time you worked, but for notices, it goes for the first time that you're owed money. And this is a critical mistake that I see made all the time, and your liens can get wiped out. So the timelines run from the first time that you're owed money. So know that's where it starts. So, you know, you're working in January, February, you need to send notice based on the January stuff if you're unpaid, right? If you get paid for January, obviously you don't send notice, you just move to the next month. So that's an important thing, because we have a lot less time than we think if we start from the first time than for the last time. And I did want to take a second here and say that your invoice date is not what matters. It's when the work was actually done. So you got to be careful when you're supplying materials or working towards at the end of the month, like the 30th. You know, we deliver the materials on the 30th, but it doesn't actually get invoiced to the 1st. And then it's, you know, if you look at your open invoice report, what you see is a February invoice when it's really not. So we need to be careful about that too. All right, important facts. Research, and so, you know, research on correct addresses for general contractors, correct addresses for owners, all of that research, and save that research in your file. If you're going to send out your own notices, make sure you check the addresses on all the letters. And what we do on our letters is we put the address and then we put the certified number, so that when the certified card comes back, we know which one is which. Or if it doesn't come back, you can take that certified number and run it through the post office. Currently, under the rules as they are now, you need to take the notices to the post office and have them stamped. That changes for the new rules. You can have it it doesn't have to be post office, as long as they can, you know, certify when things were received and when they were sent out. That, like FedEx and, you know, UPS, you can now use things like that. Each month must meet its own notice requirement, Like I said, there's nothing wrong with sending notice early, especially if you know that there's an issue. All right, so I kind of went over, you can send your notice through any company. Okay, it used to be under the old deadlines that if your notice date or your lien date fell on a Saturday or a weekend or a holiday, that you'd had to file it before that timeline. The new rules will allow you to do it the next business day, which will be nice once we get there, but that is new, that's nice, a new improvement. Specific, and now the statute has a specific form of notice that's required for like an intent letter or a GC, and for the notice you send to the owner and the general contractor. It's just basic information, you know, the address, the project name, how much you're owed, who you were hired by, so that everybody knows what you're claiming money for. And a specific form for unpaid retainage is now required. Okay. So I'm kind of going to try to generalize this as much as possible. So under the new rules, the first notice needs to be sent on a commercial project the 15th day of the 3rd month, right? Under the current rules, if you're place 3, it's the 15th day of the 2nd month after you're owed money. Make sure you have the language to add to trap funds, and we'll get into what that is here in a little bit. If you think you're working on a lease space, you can still have a lien. It depends on the terms of the lease, so we might want to ask from that. So your lien needs to be filed by the 15th day of the 4th month after you completed work or final completion. That's for a commercial project, and it's the 15th day of the 3rd month for residential. And you need to send out a notice of the lien that was filed within 5 days of it being filed. And here's the other thing is that I can tell you from just being in this industry for a long time is that don't ever assume that who you're dealing with doesn't know your timelines. I've seen it happen very often that promises of payments will push people outside of their lien timelines. And then when they're like, well, you promised to pay me, you're like, well, now I'm not going to pay you because you didn't file a lien. I don't have to pay you. So just know that, like, you know, promises of payment, don't ever let a promise of payment push you outside your lien timelines. So there's more details at subcontractorinstitute.com, or you can call me and we can talk about specifically your business and we can set something up that works for you. All right, so yes, lien law updates. You know, I think hopefully in the next round, in the next 20 years, that I'll have some input on this because I do a lot of these, and there could be a lot of other things that are changed that could be more efficient, especially for people in subcontractor material supplier situations. So, but like I said, oh yes, okay. So there is another good change that I want to get into is retainage liens. Okay, so used to be retainage liens had to be filed within 30 days of final completion, which is like an impossibility for the general contractor to get paid and then pay everybody before your lien timelines expired, right? So you had to go in there and file your lien and maybe piss everybody off, and just to be secured to make sure you get your retainage. Okay, so now retainage liens are the 15th day of the 3rd month after completion of the project, or if the original contractor you're working under was terminated or abandoned the project, 15th day of the 3rd month after that. So that means that gives them, you know, that gives them 60 days to get the money from the general contractor, to get the money from the owner to pay you before you have to file a lien. So I did think that this was a great idea to do this. Because retainage liens are such a sticky thing, and that's where everybody's profit is, right? If we're making more than 10% on the job, I think that's awesome, but a lot of us aren't, and so the 10% is our profit, and what will happen is if we don't have a lien file, they'll just, even though they get paid, they'll just hang on to it forever, and the longer you go without the money, the less it's worth, right? There is a time value to money. So I think that this was a really good improvement, that now you can file retainage liens the 15th day of the 3rd month after completion of the project. If you want to know more, give me a call. We can talk about it specifically as relates to your business. Okay, yes, next slide. Okay, and so they're getting rid of the 2nd month notice. I don't necessarily agree with this because I think a lot of the times that lets the general contractor know that the material supplier sub hasn't been paid. I know a lot of my material supplier clients say they're going to keep sending it just because that's what gets them paid. So you can, like I said, you can still send notice even though it's not required. So under the new rules, the 15th day of the second month for residential projects, and notice must go to the owner and the general. And for commercial projects, at the 15th day of the third month, a notice must go to the owner and general. And there is, okay, so under the new statute, the retainage is still there, but now it's called reserved funds. And retainage is specifically whatever is mentioned in the contract as contractual retainage. It's a legal definition that matters. All you need to know is that your retainage liens, if you have retainage in your contract, then the retainage lien timelines apply to you. Okay. Online filings service, I have yet to see one do them correctly. They don't know specifically about Texas. And you know, the detriment of doing a lien wrong can be very painful. I had a client that just had to pay $50,000 cash. And not only that, but he had to pay, his attorney's fees, $50,000, and lose the money he was owed for an invalid lien. On the other flip side, invalid liens get paid all the time. So it is crapshoot if you want to file an invalid lien. I'm just letting you know that, some of those places out there are not the best. Like I said, they're not. They just don't know what they're doing. Okay, so what is retainage? Under the new rule, retainage is whatever's withheld in a contract. It used to be retainage was 10% of the original contract that the owner was required to withhold by law, right? So retainage is now whatever is defined in the contract, and you have to the 15th day of the third month after the project's complete to file your lien on retainage. So that's, retainage is now just whatever is defined in the contract. What used to be retainage is now called reserve funds. So now the owner still has to withhold the 10% of the original contract amount for 30 days after final completion, but now that is referred to as reserve funds instead of retainage. Retainage is just what, so like a material supplier is not going to have a retainage lien because they don't have contractual retainage. Generally speaking, they're not signing a contract. They don't have retainage as defined by a contract, so they're not going to have to worry about retainage liens. That's just basically subs and general contractors would have retainage liens. Okay, next slide. All right, reserve funds can also limit the owner's liability in the same way that retainage did. So when the law requires you to withhold that 10% from the general contractor for 30 days, if the owner does that properly, that is their only liability. Meaning, like if they have $1 million project, they got to withhold $100,000 for 30 days. If they, and that is their only liability. So if they have lien claimants that are proper and are more than $100,000, the lien claimants will have to share pro rata of that $100,000 that's left. So they can limit their liability, and then reserve fund claims have to be filed within 30 days of final completion. So they also shorten the deadlines on times. The liens have to be filed. So like I said, reserve funds now the old retainage. Okay, 30 days after final completion, you need to file your reserve fund liens. Okay, sorry, next slide. Okay, file lien to make sure you collect retainage. Guys, this was important before. It's even more important now, and now you have more time. So I would, the retainage is the last part of your contract. It's where all the profit is. And so what I tell my guys is, my clients, is build in the cost of filing a lien for retainage on every project. It's, doesn't cost that much. It's already built in. That way, if you have to do it, you can absolutely file and you're secured. Because why? Go to the next slide. Because your profit is in retainage. And plus, if you file your lien, you now have an interest in the owner's property, and you can sue the owner to foreclose on that lien. You don't have to sue the person that hired you. And it is a lot less likely that you would end up in protracted litigation if you had a lien. So you have a lien claim, but you also always have a breach of contract claim, which means you can sue on your unsecured debt, breach of contract, on whoever hired you. which can be a much longer, much harder case. We streamline that process with the leverage that is created by a lien. So that is why this is so important as well. All right, trap funds. Okay, so this is another reason why, if you send notice often and early. Okay, so like I said before, reserved funds of 10% of the contract amount can limit the owner's liability. You can increase that amount by trap funds. And what does trap funds mean? Trap funds means funds that are in the hands of the owner when they receive your notice. They're supposed to hold on to those and not pay the general contractor until your claim is resolved, or at least reserve the amount of your claim to make sure that you're taken care of. So you can, so say you send your notice and you trap, my example before, retainage is $100,000, but if you sent your notice when they still had $50,000 owed to the general contractor and they paid him anyways, now the owner is indebted to the lien claimant, to you, the lien claimant that sent the trap funds notice, $150,000. So we can enlarge that reserve funds amount if we send notice early enough to trap the funds in the hands of the owner, right? So this is an important thing to know. Again, like if you feel that there's something going on, trust your gut, just send the notice, right? You can trap the funds and enlarge the amount that you're owed, and would be able to collect specifically from the owner trying to dodge liability by the 10%. So that's what trap funds means here. There's special language that needs to go in your notice letter about what happens if it remains unpaid. To have that trap, that's the special language right there. So if you're sending your own notice letter, it's always good to send this at any notice that you send. That way, you can say, hey, I trapped funds way back here, even though all these other guys didn't, I didn't. So I'm entitled to this larger amount. I'm more likely to get paid everything that I'm owed. Okay, trap funds again, I kind of went through that. I made it. Wow, I didn't think I was going to make it all. I know it kind of fast, but here's the thing, guys. If you need help, we're here. We also offer some great subscription plans where you can basically outsource your collection department, and we'll handle all the phone calls, the notices, the liens, everything. So if that's something that you're interested, we sell, we piecemeal liens. Collections is really our best thing, where we can collect money. As I had to do it on my own, I know how to do it, and we're very good at it. And most of our files get paid. Over 90% of our files get paid without ever having to file a lien, because we're not just a lien filing service. Our end goal is to collect your money, which means we're making phone calls. We're doing everything we can to get you paid, not just file a lien. And also, we're a one-stop shop for any business in construction. We have contract review, contract creation, all for a flat fee, whether you're residential or commercial. Subcontractor Institute has some great free resources if you have questions about what's in your subcontract and collections. Again, I'm here to help. So I know that was a lot, but if you have a specific situation you want to talk about, you can take yourself off of mute or put it in the chat. I'm here to answer the questions.
Thank you, Karalynn. I appreciate it. All right. Yes, so please feel free. You can send me anything in the chat. I'll read it out to Karalynn, or go ahead and unmute yourself. Don't be shy.
I mean, pick a lawyer brain.
Yeah. It's not every day that you can pick your brain, Karalynn.
Even if it's not about collections, we got some time.
Yeah,
so I'm here to answer all the questions.
absolutely. Yeah, we have you until 1 p.m.
Yep.
Hello.
Hi there.
Hi. So I do have a question
Yes,
on the time to send the notices. So I've been told this once, maybe I misheard, but say a project is 3 months.
Okay.
And when I've been told that even if we ended in April,
Mhm.
Say the job started in February, we ended in April. Can we still send the notice out after the project is done, like completely done? Do
A
we still
notice
have
for,
time?
I mean, we can send the notice, and it depends on how, if you're owed for retainage, we could file the lien. So under the current rules, you have 30 days until final completion to file your lien. Under the new rules, it's the 15th day, the third or fourth month, depending on the project. So you are, what kind of company are you? Material supplier, subcontractor?
Material supplier.
Okay. And so you're delivering materials, give me 3 months in a row, right?
Yes.
So like January, February, and March. So your first notice for those January invoice needs to go out on March 15th, just to the general contractor.
Okay.
You can
Okay.
send February with it. You can send February with it if you want, but yeah, that first notice, in order to have a valid lien, needs to go out then.
Okay. So you can include 2 months as well. You don't have to do it month by month.
Yeah, you can include them. You can include them all together. So basically, you do 2 months, skip a month, 2 months, skip a month.
Oh, okay.
Yeah.
That's
Yes,
good.
absolutely.
Okay. Awesome.
If you have, multiple jobs, you can, put them all in one envelope. You don't have to send multiple envelope. If you have the same GC for multiple projects, you can put them all in the same envelope as long as it's trackable.
Awesome. Thank you so much.
Hi, I have a quick question.
Yes.
So a lot of times what our problem lies is with retainage. So sometimes we work as either a GC or a sub. And when we're working as a sub, our GCs a lot of times will tell us we're not even applicable to bill retainage yet because their piece of the project isn't complete. And I find that very odd because our contractual agreement is with the GC and we're finished with our work. So why is it that they come back to try to tell us that we can't bill for retainage? Is that just them trying to cover themselves to make sure they get paid retainage too?
Well, and probably what they're relying on is the pay when paid clause in your subcontract, which means basically you're not entitled to be paid the money until they're paid. And so that's what they're saying. But here's the thing, that does not stop you from filing a lien.
Okay.
So, and what it's aggressive, but it does make you to move to the front of the line is that, when you're done, you just go ahead and file your lien for retainage. You can do that, or you can, when the project's done, go ahead and file your lien for retainage. And that way, one of two things is going to happen. Either the GC is going to pay you directly with retainage, or the owner will pay you directly out of the retainage. And that way you make sure you get paid retainage, because as you know, if you don't do that, you're 6, 7 months, and maybe you get paid retainage.
Yeah, and sometimes even years. And what happens though is, so a lot of times we work for municipalities. Well, we can't really file liens on those. We have to file bond claims. So I just want to make sure we're not missing anything or missing deadlines with these bonding companies if we have to file bond claims when it comes to retainage, because it's kind of a gray area and I don't want to miss collecting retainage, or if we're able to actually bill for it contractually. I don't want to go just off of what they tell me. So it kind of
Great.
makes it a little difficult at times
And
to know
and
what we.
and here's what the new the rules are going to be. So like with a bond claim, you're a subcontractor generally, right?
Uh-huh.
The 15th day of the third month is
Okay.
when you're going to have to send. And here's the thing is that the same timelines kind of for retainage apply to bonds, but you can file your bond claim notice and just sit on it, right? Especially bond claim notice. There's nothing aggressive about that because it's not a
Sure.
lien on property, right? So
Right.
just send it when you're done and you haven't been paid everything. If after 90 days, just send the notice to the bond company. And that way, just send it. You have to send the notice. It's got to be like notarized. It's got to be done right. But if you do that, then you've preserved your claim. And if you don't get paid, in 90, whatever days, then we can pick it back up. Because under your contract, technically, although you've done the work and are entitled to file a lien, your payment terms are based on when the general gets paid.
It's paid. Okay.
So, yes. And if you ever have problems getting your bonds, I have a great trick for that.
Okay. Yeah, we might be reaching out for that trick
Yeah,
sometimes.
absolutely. Give me a call.
These.
What we do is like, so that 15th day, the second month notice, that's not
Uh-huh.
required for subcontractors. We send it to the general contractor, which is your customer, with just a statement of how much we're owed and a statement that says, hey, we're requesting a copy of the bond. and they look over it, right? They just whatever. And so when the next month, when your back's against the wall to get the notice out by the 15th, you can say, hey, no, I actually sent it. You're actually late in giving me the bond. And so that's been pretty successful, because that's one thing, if I got the chance to change in the statute, that I would, just because it's a GC bond. Like, why would they ever want to give it to you?
Right. Right. And half the time we struggle even getting them to provide the bond information. So
Absolutely, absolutely. And so that's we have, a lot of customers that do a lot of public works jobs, and that's kind of what that's a trick that we find works real well.
okay, thank you.
Thank you. It looks like we just got a message from Chantel in the chat. Karalynn, after you've missed lien and bond deadlines, is a lawsuit the only option to getting paid?
There are some other limited options. There is something called, if they've, violated a trust fund, but that's a really hard cause of action to prove. It's basically you're proving fraud. So yeah, you have your breach of contract claim against whoever hired you. And that's, here's what we do too, is like if a client comes in and we say, hey, you missed your notice timelines, we'll still send the notice, like the intent. We won't file the actual lien, just to see if we can, stir up something to get you paid.
Sure. Thank you. Do we have any more questions for Karalynn? Looks like another one just came through. Yes, providing templates for notices, residential or commercial. I'm going to send an email out with a bunch of, with everything that you'll need. But Karalynn kind of mentioned the residential and the new templates that we've actually created custom. So it has all the new.
Is that in our this month's blogs articles?
It is. It's in the blog articles. And then we were going to send it out as well for the attendees that joined us today. So we'll be sending all of that out. It has all the updates from as of January 1st this month. So be on the lookout for that email. I'll send it out today, as well as this full presentation, so you can refer back to it with your handout. I'll also have a link. I think we'll be posting probably tomorrow on our social channels and YouTube channel for this copy of the webinar. So if you ever want to refer back to it, you can check out that. And then another question came through. I understand that waivers don't require notary anymore.
I think the statute still has them as being notary. I mean, okay, let me see. There's no official rule that says notary is not required. I know that because of COVID, everybody's kind of been stretching the rules, and if you can prove that, somebody sent it to you and you replied, then that's been working. But as far as, yeah, it's still required under the rules. Yeah, double check, but that it be notarized. I know it's a pain in the butt.
Right. Any other questions? Thanks, Chantel. Just thanking you, Karalynn, for the informative information.
Anytime.
All right. Well, if we don't have any other questions, again, I'll be sending an email with those templates and then all the links directly to blogs that we've posted this month. Be on the lookout in the next week for our last blog the series. And yeah, we just thank you so much for joining us today, and hope to see you all soon. We host monthly webinars. Karalynn is always creating new content and writing, so be on the lookout for new blogs on our website. Lots of just really good information that's crucial for protecting your business and building better businesses. So we appreciate all of your questions today, and thank you for attending. We'll see you next time.
Have a good day.
Thank you. Bye-bye.